Hi, I'm Becky Kinnaman, Director of Crimes Against Persons for the State Court Administrator's Office. I serve as a dedicated point of contact for judges, clerks of court, and other professionals to assist in creating appropriate responses to crimes against persons as related to domestic violence, sexual assault, stalking, and other matters. Crimes of violence against women are often unreported and are underreported. I'm motivated to assist court personnel who have contact with crime victims and defendants because it can make a very real difference in those whose lives are disrupted by these crimes. I'm often asked questions about firearms regulations and how they relate to domestic violence. This video will address firearms prohibitions in both civil and criminal domestic abuse assault matters. When issuing temporary or ex parte protection orders under Iowa Code Chapters 236 or 598, the court must provide notice to the respondent that they may be required to relinquish firearms, ammunition, and offensive weapons upon issuance of a permanent protective order. Iowa form orders comport with this requirement. When issuing a final civil protective order under these same code sections, which is orders that are issued after the respondent has had the right to be heard and present evidence in the case, those orders shall prohibit the respondent from possessing, transferring, shipping, receiving, or selling firearms, ammunition, and offensive weapons for the life of the order and any subsequent extensions which are granted for that order. The order shall also direct the respondent as to the procedure and time deadline for surrender of those items to the appropriate authority. A defendant subject to a criminal no-contact order in a domestic abuse assault case is prohibited from possessing, transferring, shipping, receiving, or selling firearms, ammunition, and offensive weapons for the pendency of that order. The order shall also direct the defendant as to the procedure and time deadline for surrender of those items to the appropriate authority. Yes, but the official use exemption applies only to the service weapon of a law enforcement officer while that officer is carrying out official duties. The exception does not apply upon conviction of a misdemeanor crime of domestic violence. No, as of 2010, Iowa Code is very clear. Prior to that, in Weisenberger v. Iowa District Court, our Supreme Court concluded that the District Court had no power to authorize a defendant to possess firearms in violation of federal law. Once the court determined a no-contact order should continue in effect, the defendant was prohibited under federal law from possessing firearms, regardless of whether this prohibition was included in the court's no-contact order. Upon conviction of domestic abuse assault, the adjudicated person is prohibited from possessing, selling, shipping, transferring, or transporting firearms, ammunition, and offensive weapons for the remainder of his or her life. Iowa Code 724.26 sub 4 provides that persons subject to applicable domestic abuse assault protective orders or no contact orders and those who have been convicted of domestic abuse assault shall be ordered by the court to sell or transfer firearms, ammunition, and offensive weapons to a qualified individual or to order the person to transfer such items to the local county sheriff or local law enforcement agency designated by the court for safekeeping. Best practice recommendations per the National Council of Family and Juvenile Court Judges, the 2008 Iowa Supreme Court Task Force on Domestic Violence, and the 2010 Iowa Court Domestic Abuse Bench Book state that the person subject to such orders, or for persons convicted of domestic abuse assault, they must first surrender those firearms, ammunition, and offensive weapons to the locally designated law enforcement agency for safekeeping. If transfer to a qualified individual is requested, the court should hold further proceedings to determine whether the proposed transfer is in the interest of justice, public safety, and can legally take place. Courts should conduct colloquy with proposed qualified persons under oath. The colloquy with this person should include, but not be limited to, determining: is he or she a convicted felon? Is he or she subject to a domestic abuse protection or no contact order? Does he or she have a domestic abuse assault conviction? Is the person in front of you a person of good moral character? Are they prohibited by a list of federal disqualifiers under 18 U.S.C. 922G? Would the person live in a proximal location to the defendant or respondent? Does the person live in the same house or apartment as the prohibited person? Is this person an immediate family member of the defendant or respondent? How easily could an offender access the materials if surrendered to this person? Under oath, does the person acknowledge that allowing the subject any access is a violation of the law? And lastly, under oath, does this person acknowledge that crimes committed by the offender with these weapons or ammunition subsequent to surrender could result in their being charged as an accessory to the crime? On behalf of the Iowa Accountability Program's Judicial Training Institute and the Office of the State Court Administrator, we would like to thank you for your dedication and work to keep victims safe and hold offenders accountable. As a reminder, if you have any additional questions, please feel free to contact me using the information listed below.